The General Data Protection Regulation, known as GDPR, is a new European data privacy law which was approved on April 27, 2016. But it will be on May 25, 2018 when it will be fully applicable in all member states, replacing the previous Privacy Directive. The GDPR aims at protecting the rights and freedoms of natural persons regarding the processing of their personal data. At the same time, this new regulation seeks to reinforce and grant the same level of personal data protection in all EU member states. Given that the purpose of the new GDPR is to give EU residents control over their own data, it will regulate the way individuals and companies gather, process, store and eliminate personal data of EU residents. Thus, its definitive application will not only have implications for European companies, but for any company that stores and processes data from EU residents. One of the most important changes that the GDPR introduces is the need for companies to demonstrate lawfulness in the collection and processing of personal data. The regulation establishes 6 different ways for companies to comply with Article 6. One of them is to obtain consent of data owners to process their personal data for one or more specific purposes. Consent must be also obtained in a lawful manner for data processing to be lawful, and it must be freely given, specific, informed, and unambiguous. Companies that base data processing on consent must be able to demonstrate that the data subject has consented to process their personal data. These and many more of the changes introduced by the new regulation are far-reaching, which means that, on the one hand, companies must understand why and for what they need to collect and process personal data. On the other hand, they must understand the legal and technical implications of adapting or modifying their established procedures to collect, store and process personal data.